Alrighty, so this is Diesel with People News one more time, y'all. Alright, all these videos is just my opinions only. Do not take legal advice whatsoever, okay? I'm not the brightest guy in the world, so always do your own research, okay? I'm doing this to benefit my family only, okay? You can kind of listen and think outside the box and see if it will benefit you or not, okay? I cannot determine that for you, okay? There's just a couple of things we want to go over. Cops are executive branch. They cannot make legal determination. They cannot have a summons for you to go to court. And yet, because of us being dumbed down by our schools and by hearsay and tacit agreeing to everything, we assume and presume that these officers actually have this much power, which they do not. Remember, the only time you can actually go to jail is if they have a warrant. If no warrant, they are trespassing upon you and kidnapping you. Alright? Now, the only way they can actually do it is if they actually seen the crime at hand. Their police reports are hearsay. Okay? The witness must sign an affidavit and under penalty of perjury. And this is what we keep bypassing. This is the reason why innocent people go to jail. This is why kids are getting kidnapped, because of hearsay and no witness are signing any affidavit. Alright? CPS and family courts, this is all done without affidavits and penalty of perjury. It's all done by hearsay. And it's admissible, like this guy right here, right? As far as I'm aware of, I have not seen the paperwork, but I'm willing to bet there has not been a witness sign an affidavit under penalty of perjury that he's committed any harm to anyone. And probable cause, well, officer thinks he has probable cause. Well, now the officer is acting as attorney. He is making a legal determination he cannot do. But because we tacitly agreed and assumed to presume that he can do these things, well, they're not going to tell you the truth. They're going to let the officer go ahead and arrest you because you didn't know your rights. You did not know your due process. And we've gotten so far away from our warrants, it's unbelievable. And then they just no knock warrant. The warrant is show you verifiable proof that they have probable cause to bring you into their jurisdiction. Period, y'all. That's the reason why there's a warrant. If they can just come and willy-nilly pick you up for any reason without a warrant, then they can do it at any given time. Which is what they're doing now, right? Just because the guy assumes, the officer assumes they have probable cause. Just saying. Without him having first-hand knowledge, the officer needs a warrant. The courts needs a warrant to come and get you. If they do not have that warrant, then it's a violation of due process. And they just kidnapped you. And kidnapped your kids. Alright, let's go.
Attorney Mr. Bob Gregory just stated on record that he had absolutely no problem with the approval of that, with the exception of one specific paragraph. And again, I requested on record that the court, before they issue any determination on any of my motions, that those be put down in written form, not under verbal, as I was required to put it down on paper. I would like the state also to put it down on paper. That way I can properly address each line for line and as to why in another motions hearing before the court denies that. That is a
And that's a rebuttal. That's very important. You need rebuttal, especially the word "you." Just by itself, y'all, if you don't rebuttal anything else, there's one word that you can always use and rebuttal against: you. You is a noun. It's also a banking word, means debtor. Okay? So that summons is saying that basically you need to appear in court in X amount of time. Well, they're saying the debtor needs to appear in court at a certain time. Why? Because they're assuming you're a part of the corporation because you tacitly agreed to their ordinances and you tacitly agreed that you're a resident.
failure of due process in which I have requested, the court mandated me to do it, therefore I am requesting that the courts mandate the state to do the same as well.
Possible dimility. They don't want to take responsible actions for themselves. And that's the reason why they're not doing it. You got to listen to this very closely, what the prosecutor is going to say, because it's hard to hear.
I certainly can if the court, if the court is requiring a response in writing, we're happy to do it.
Okay, well,
Why does that attorney need the court's permission to do that? Sit and think about that. He's supposed to already had it done.
how long will it take you to respond in writing?
About the next court date.
Okay, so we will continue this matter to the 9th of November.
And
Does that give you enough time?
I think so. I mean, if Mr. Anderson wants time to respond.
yes, please.
Okay,
Mr. Anderson needs to rebut this Mr. Anderson thing. That prosecutor needs to address him as a man and use his full name.
okay, why don't we continue the hearing to the 14th of December for the hearing with the motions or the reply brief to be done by the 9th of November. And since Stephen Trial is not running,
How would the court like us to provide that, our response to Mr. Anderson? Should we get it to the court?
yeah, I guess that would be probably the most efficient. The court will have the reply brief by the 9th of November. That is when we have court. You can come in by noon that day and get the reply briefs, and then the hearing will be set on the 14th of December. Do you have any questions on any of that?
Along with that, since they're asserting jurisdiction based on the people of the state of Colorado and also the town of Breckenridge, I would like that in the motion too, as far as not necessarily discovery. I don't need the entire discovery of the case. I just need to know who the competent facts witness is, who the damaged party is, and who brings the claim and who is underwriting the action.
There is a process that is followed. You have not entered your pleas on any of these charges.
See, now the judge wants him to make a claim. The burden of proof is on them right now because that officer made the claim. The prosecutor is making a claim. Now, once he makes a claim that he's innocent, not guilty, no contest, now he made the claim and the burden of proof is on this man here. Now, that's what they want him to do. Okay? To release the burden off the state and put it on him. This is the reason why you don't want to make a plea, because that is a claim. And now, since you are the claimant, always has the burden of proof. Always. And they're stuck on him making a plea to get rid of their claim. Now, again, that's just my opinion. I'm not an attorney. I'm not giving legal advice.
It would be my understanding that discovery of what you are asking would be provided after you have entered your pleas and the case is proceeding. Would that be correct, Mr. Glader?
I believe so, although, I don't object to, court providing Mr. Anderson with a copy of
The police report.
the report.
Well, I have the police report, but that, again, that's a police report. That's not actually who brings this matter to the court.
Mr.
Because
Glader, Mr. Anderson, the police report is what the people have control of at this point. That is what is sufficient. Now you're just,
So the judge says that police report is what the people are going by. Well, again, y'all, that police report was by hearsay, unless the officers seen firsthand knowledge of this. Okay? So the judge is basically saying, well, we're going to go by hearsay, and the prosecutor is going to go by hearsay, even though you have facts. We're going to go ahead and stick to the hearsay because that's what we do. All right? The municipal court, see, men and women not even supposed to be in the municipal court anyway. We're supposed to be in the district court. We're not even supposed to be started off in this court anyway. This is for corporations and corporations only. Contract, businesses. Remember, ordinance is a bylaw, which is what I call a bypass law. All right? Legislatures only make laws. Your city councils can't make laws, right? But they do call it a bylaw, which, again, we just said it's a bypass law. They bypass the law to create their own power trip.
you've got a copy of the police report, is that correct?
the police station has
Is it yes
provided
or no?
a copy of the.
I would just tell him yes or no. He wanted to answer. I'd just go yes or no. I gave him the answer he was looking for.
Report in which happened that day. So if the police are going to be present, all of the officers that were there, and they are the injured party, then I suppose I don't need further validation as to who brings this matter. Because again, I believe that it's under constructive fraud
It's
that
not
they are
constructive fraud.
bringing this against a person or a corporation.
One, it's not constructive fraud. It's not treason. You should probably choose your words a little more carefully, but that is your choice. You have a copy of the police report. Do the people have anything further than that?
Well, I think regarding Mr. Anderson's request, it sounds like what he's getting at is he wants to write the opportunity to confront the witnesses against it, the trial is never witnesses against it. That's exactly what the trial is for, so that the plan, we get to a point where a trial is scheduled, the people will present the witnesses, against you on this matter, and you will have a right to cross-examine those witnesses. That would include the police officers, that would include Mr. Rodriguez, the driver of the other vehicle on this matter, and the other witnesses, that you will bring in front of the court. Mr. Anderson's constitutional right is the right to cross-examine those witnesses, and you will be afforded that right.
And I've also given this court to caveat on that. I believe it was on the 8th of August, roughly, this court was provided a rescission or an affidavit of rescission in which everything was taken away from this court as far as any contracts that I had entered with this court unknowingly and unwittingly. That would include the police ticket in which was signed. It was rescinded. This court did not file within 21 days a rebuttal, and or the prosecution did not file a rebuttal, so that stands as truth in commerce. And so I would also like to know where the contract is.
The court stayed in silence of acquiescence and tacit agreed to his terms. So they're stuck on there. However, they're going to still proceed forward on this, which goes back into what he said, right? They're either committing treason or fraud. If they keep proceeding forward when it stands true in fact because they didn't do a rebuttal and they tacitly agreed to his terms and they stayed in silence of acquiescence, that's exactly what they do to us. So if they don't stand in good faith, now they're actually committing fraud and treason by punishing him.
And the 1099 OID is for this matter. I would also like those brought into, or been presented to me as well. Because again, with that rescission, this court does not have jurisdiction over any of this matter, as I rescinded everything with a contract that was unrebutted to the people of the state of Colorado and to within this court, and nothing.
The court does not have jurisdiction because he's not a corporation. He can let them know on record that he's not a member of a corporation. So therefore, it still stands as true in fact that they don't have no jurisdiction, and they did not show verifiable proof that they must show they have jurisdiction by their own Supreme Court laws.
Has been provided to deny that or line for line rebut anything within that.
Are you aware of any of that?
I haven't seen that filing.
I haven't seen that filing either, and it should be noted that your initial court date was the 10th of August. You failed to appear. We sent a letter for compliance, and then on the 14th of September, you appeared, refused to, did not enter a plea, and the matter was then set for this date. So,
If I may really quick, Your Honor, I have the actual copy in which was filed to the court here, and it's also been filed to the clerk and recorder's office for the state of Colorado. So it is on record both in this court and also with the state of Colorado on record that I did file this, the affidavit of rescission, and nothing has been responded to within the required 21-day time period.
interesting in looking at the filings in the court file.
In fact, I have a copy of it in my vehicle.
Well,
I have the original, I should say.
I see a notice of rescission.
That would be what I'm referring to. That is my affidavit of rescission, in which was not rebutted or responded to within the 21-day time frame.
Sure. There you go. I don't see a filing stamp on that.
You mean with the date stamp, is that what you're referring to?
Yes.
Again, I have the original in my truck because it was stamped with the red Town of Breckenridge stamp from the clerk's stamp upstairs. I made sure I got a copy of that because I recorded it with the state's clerk and recorder's office to make sure that it was affirmative on record that after 21 days that is truth in commerce, and that has not been rebutted to, and it has not been, nothing has been done with that. And so that stands as fact and truth.
I guess just generally the people's response to this is that this notice of position has a legal merit from the perspective of is from this court. This court and the jurisdiction of this court doesn't require consent of the defendant. To the extent, Mr. Anderson, it's consent.
The attorney just said that the court does not require consent. So, essence, the courts are basically saying we can do as we wish because we have sovereign citizen immunity and we're the kings, and you peasants must bow down to our wishes, that you have zero authority because we are your bosses.
His consent to these proceedings.
I'm sorry, but I don't understand that because
No merit for that notice. The people certainly don't recognize it.
And I don't understand why the court would entertain that, as again, they had 21 days in which it was filed, which I've provided everything filed, and I've also, everything that has come to this court has been subsequently filed as registered mail as well, so that way I established common law jurisdiction within this court. And the court is still operating under admiralty law and contract law, which, again, I've established common law within the court in the matter.
Of course, the matter, you're citing common law. This is statutory law that we are dealing with. All criminal violations are statutory. They're not common law. And so common law really has no bearing. The rules of the municipal rules of procedure are the governing rules for this court, with some guidance from the rules of Colorado rules of criminal procedure. So what we are dealing with at this point is our next hearing on this matter will be on the 14th of December.
Now, you guys gotta have to pay attention to that one part right there. Again, we are a common law country. This man has authority and legal and lawful right to a common law court. The reason why the judge don't want him in a common law court is because the judge knows he has authority in that court. So the judge is keeping it in a statutory where he can still be the king and authority. Alright? And you peasants must stay on this side of the line, that you don't have constitutional rights. Common law, you have constitutional rights. Codes and statutes and rules and regulations is privileges. You have no constitutional rights. Now, they throw Constitution in there every so often to make everything look good. And every now and then they throw common law in there to make it look good. But, lawfully speaking, and legally speaking, They are two different jurisdictions. One is for men that has rights, which is common law, and statutory is privileges where you don't have rights. You have statutory is this privilege that you just, it is what it is. They're the boss of you. Common law, you are the boss of the judge and your government officials. Codes and statutes is they're the boss of you. So common law, you're the CEO of Walmart. Codes and statutes, you're their employee.
People will file their response to your motion on the 9th of November. If you will please take this to the clerk, she will give you a filing notice as to the hearing on the 14th of December. Once again, that will be at 11 a.m. And the matter will be taken up at that time. Now, I will ask the security person to take this with you to the clerk, and she will give you your notice for the next court date.
I already have that notice. You've provided me with the date.
You don't have that notice because we just made that on the record, and we will give you a paper notice of that hearing date.
Okay, so I don't understand how this court can still operate under admiralty law when I've established common law within this court. I don't understand any of what's happening in this court right now because,
We just
again,
explained to you that we're operating under constitutional law. I don't know what you're talking about.
again, you're operating under contract law.
No.
You want somebody to explain it to you, but it's not.
We're not.
People will put it in writing, and I will provide a response by November 9th. If you want to then decipher it, decode it, and still argue that we're operating under admiralty law or any other kind of law you want to argue, we certainly can after that date. But to the extent you don't understand it, it's not my job to make you understand.
Prosecutor is absolutely 100% wrong. They can use the Constitution and statutes, but when they use the statutes in the Constitution, they're using it as a benefit of the contract, which is basically saying you are the employee. Okay? But common law also as well has Constitution, but you either have the authority and there must be a victim. And it must go by facts. Right now they're going by assumptions and presumptions, which is codes and statutes in general, which is legalese. My opinion, not attorney.
I think it's you guys that don't understand that this is common law, that we are in the United States of America. We are not on the high seas right now.
Excuse me. Common law has no bearing on criminal law. This is a criminal action.
Okay, and
It's governed by statute.
common law can govern both criminal and civil matters.
Interesting proposition.
The judge says, interesting proposition. It is true. Common law is, in fact, criminal or contract. It's just statutes has been taking over the common law and civil matters and all that kind of stuff. Everything is based in contract law now. Just saying. For some of y'all guys, it's kind of hard to explain, but it's it is what it is.
Has little bearing in this case. Cameron, if you'll please take this file with Mr. Anderson and tell Maddie that we need to set this for a motions hearing on the 14th of December. It's written out there. Thank you very much.
So to take the front to the Maddie.
Take it to Maddie. Yeah. Maddie will provide you with a notice on that.
And really quick to ask for the court, being indigent and also under Title II of the Americans with Disabilities Act, being a disabled vet, do I need to set a motion or file a motion in order to get the transcripts from this hearing and also the last hearing so that I could submit those to the 10th Federal Circuit?
See, okay, again, common law, we have rights. Statutes, we have privileges. So we technically do not have to pay for these things because we have a right to it. Now he's asking him to be indigent, which again is giving him jurisdiction so he can get something that doesn't cost money that he has a right to in common law without paying. Because if they charge him for it and he don't have the money, that's denial of due process. Right? And this is in most states in the Constitution. Okay? But you have to stand as a man with rights. Okay? Now, if Walmart wanted these transcripts, if Walmart is using the courts as a privilege, they would have to pay for the transcript, McDonald's or whatever, right? But if you're standing as a man that has rights, you don't have to pay for these things. Okay? Understand the difference. And this is, there's so much here, it's unbelievable.
I'm asking as far as being indigent. I know usually you have to pay for transcripts.
To prove that you are indigent, and we can have a hearing on that on the 14th of December.
See, now they want him to prove that he's indigent, right? Again, what they did is saying Walmart does not have enough money to pay for these things. So now Walmart's got to prove that they don't have no money to pay for these transcripts, and they would do him an indigent. But because he is a man and he has rights, he has a right to these paperwork to be able to proceed forward with his due process. Okay? Not attorney, not giving legal advice. Look up your own state constitution.